And I have the honor to give the stage to you, Bryan.
Thanks, Oliver. So, by way of quick introduction, my name is Bryan Hollman. I am a New York attorney, and I work as counsel at Stadler Voelkel. Just to add on to the legal disclaimer that Oliver gave earlier, this presentation is not legal advice and is for informational purposes only. So what I'm going to be talking about is U.S. legal considerations to keep in mind in running an ICO. You may ask yourself, why is this important if I'm issuing these tokens in Europe or somewhere else in the world? The Securities Act of 1933 makes it a crime to sell or offer unregistered securities in the United States without an exemption from registration. The SEC and the Department of Justice, the SEC is the United States Securities and Exchange Commission. They're the federal regulator in the United States of securities. They have said time and time again over the last year or two that tokens or coins or cryptocurrencies, whatever you want to call them, can be securities under U.S. federal law if they fit certain characteristics. We've seen that over the last year with the Dow report, Munchie Inc. cease and desist order by the SEC, and then even more recently with some criminal fraud cases by Arise Bank and Centra Tech. So this all begs the question, when can a token be considered a security under U.S. securities law? And that's exactly what I'm going to cover. So a security under the Securities Act of 1933 is this massively long definition. The point of this slide is not for you to read the whole thing. You don't need to memorize it. It's just to show you that a security is an incredibly broad term under the federal securities laws, and it pretty much encompasses a lot of things that you may not traditionally think of or label as a security. The operative term that we're looking at tonight is whether something can be considered an investment contract and thus a security. And so to see what exactly is an investment contract, we have to look at a 1946 Supreme Court case that promulgated the Howey test. It's a 4-element test, and the opinion states that an investment contract generally is an investment of money in a common enterprise with a reasonable expectation of profits to be derived from the entrepreneurial or managerial efforts of others. And I'm going to go by one and apply each of these factors to cryptocurrencies and to tokens. So the first element is an investment of money. This is actually relatively straightforward in terms of tokens. Money is anything of value. It's not only cash, but can be Bitcoin or Ether or any other cryptocurrency that has value. Because it's pretty straightforward, I'm just going to move ahead to the next element. The second element is a common enterprise. Legally speaking, it's actually quite complicated because there's a split amongst the federal circuit courts as to what exactly the test should be. The two tests are horizontal commonality test, and the second is vertical commonality. Horizontal commonality requires the pooling of investors' funds that tie the fortunes of each investor to the success of the overall venture. In some courts, even, it gets more specific than that. The profits have to be distributed to investors on a pro rata basis. The second test is vertical commonality. There are two variations of it. There's narrow and broad. Narrow economic successes of the investor and the promoter must be mutually dependent, and broad success or failure of the investment must be dependent on the expertise of the promoter. Now that's a lot of technical legal talk, but I think at the end of the day, most projects are going to be investments in a common enterprise. Usually there's a developer who's developing a platform or an ecosystem or some kind of enterprise, and I think you can assume in most cases this test will be fulfilled no matter what test you view it under. So the third element is probably the most controversial of them all. There's been a lot of talk these days about what this element means and applied to a cryptocurrency context. A reasonable expectation of profits means basically that you expect to have a financial return on your investment, however that may be achieved. The point of confusion is that this test turns in part on the motivations and expectations of the investor. And there's no expectation of profits when the investment is in a commodity for the purpose of personal use or consumption. And some examples I like to give for this is if you go buy a ticket or a token at the vienna-node.eu to go ride a roller coaster, or if you buy tokens to wash your clothes at a laundromat, you're not buying those tokens because you expect that the value will all of a sudden go up and then you can sell them for a profit. You're buying them because you can consume them either by riding the roller coaster or by washing your laundry. So in the context of crypto, this gets complicated when you start to talk about utility tokens. Tokens that have some kind of utility value, they can be used in some way that's separate from just being traded on a stock exchange, for example. We got some clarity from the SEC earlier this year, or maybe it was late last year, in a cease and desist order that was issued against Munchie Incorporated. Munchie Inc. was a company that was developing a food rating app, and they issued their token, the MUN token, that was to be used on this app to incentivize users to rate restaurants, rate food, and maybe they could even order food using the coin. The SEC in their cease and desist order explained that a reasonable expectation of profits include priming purchasers' expectations of profits. This includes use of blogs, podcasts, social media, promotional videos, etc., that tout the value of the token gaining in value, or even evidence of trading on secondary markets or planning on trading on secondary markets. And also they highlighted this argument that that Munchie was making that the more people who participate on this platform or ecosystem, the higher the demand for the token will be, and thus the price will increase. All this constituted a reasonable expectation of profits through priming purchasers' expectations, all despite the fact that the MUN token had certain utility characteristics. And then the fourth element is not too complicated. The profits have to be derived from the management effort of others. And this, I think you find in most cases where it's not obviously the investors who are doing the work, but it's the development team or someone else. It doesn't have to be just the development team, but there has to be a significant effort. The courts have explained that this is a flexible rather than a static approach, so I think in most cases this will be not a problem. So just to conclude, the bottom line is that it's a crime to offer or sell unregistered securities in the US. Tokens, even those that have utility characteristics, could be securities under the Howey test. So going forward with your ICO, you basically have two options. You can either exclude the US from your ICO entirely. There are several ways to do that. Or you can try to seek an exemption from registration. There are several available, but depending on your project, there could be more or less, a couple that are more or less suitable for you. If you choose to go with the later option, you have to be really careful because the SEC is closely monitoring the space, and they will be watching if you issue securities in the US. That's all I have.
Thanks a lot.